So some of these are laws and some of them are not laws.
Well, they're all laws in the broader sense of the word.
Right.
So I think, let's just say in the 20th century or even in the 19th century as well, we used to think of law in a very top-down sense, in a very formal sense.
Yeah.
We used to think that law meant legislation. And in common law countries like England or Australia or Canada or the US, for example, we also include case law as formal law. So when a judge makes a decision, that decision may have legal precedent value. But 21st century contemporary regulatory theory says that we need to think much broader than that, right? Because there are a lot of what they call regulatory actors involved now in making law, and regulatory actors are people like, in the mediation field, mediators, lawyers, users, sort of litigants or other disputants, courts, any sort of institutions that might refer mediation, and also your formal policymakers. Think in the mediation world, how many people, and probably people listening to this now, some of you are really actively involved in mediation. You're going to meetings, you're involved on working parties, writing codes of conduct, right? You're a regulatory actor making mediation law. Now, if you've got an agreement to mediate, which, for example, which sets up all sort of the rules, if you like, for your mediation, you may import into that agreement to mediate some institutional rules, say for the ICC or your local mediation institution. If in the unusual case that something goes wrong along the way and you have a disagreement with the other party about some aspect of that mediation, and that goes to court, the court is going to be interpreting the terms of that agreement.
Yeah.
So that is law. If you look at the European Union Directive, the European Union Directive of 2008 was a document that many people listening would be familiar with, that basically said all members of the EU, all member states, have to regulate these 5 aspects of mediation. But if you read it carefully, the directive also says how you regulate it is up to you. And they give examples of different regulatory forms. They talk about codes of conduct. They talk about soft regulatory forms and harder regulatory forms such as legislation as well. So even the EU directive specifically and explicitly envisages, if you like, a regulatory mix, a wide range of regulatory forms. And by having this wider mix, it gives us the ability to treat some aspects of mediation in a flexible way and other aspects of mediation in a more rigid way. And that's important because sometimes you want certainty, and so you'll pick legislation because legislation is interpreted in a very rigid way. And depending on the terms of the legislation, sometimes parties or users can't change that, right? But if you want more flexibility, you'd be looking at institutional rules or writing your own terms in an agreement to mediate, for example. And so, this, in the mediation field, more so than any other field that I know, you have a very wide range of active regulatory actors and a relatively wide range of regulatory forms that are really in use.